In the recent years, apart from the politicians and the civil society organizations, the Uniform Civil Code is advocated and supported by city-bred, anti-Muslim, upper caste Hindus. Most of their arguments are false and not based on ground realities. I firmly believe that the people who talk about the Uniform Civil Code in channels and the social media today have very little knowledge about the Indian legal history. Their pattern of talks would always be the same. They start talking a little history about the debates surrounding the Hindu Code Bill that happened in India after the independence, how the bill introduced monogamy and established some uniform personal and common laws for the Hindus in the form of 4 acts. Then they jump right into the 1980s, the Shah Bano case. They picturize the Supreme Court as a savior for the day, and its subsequent request to the Indian government to consider introducing the Uniform Civil Code. So nothing happened between 1955 and 1980 in favor or against the need for the Uniform Civil Code? Did Hindus receive any justice at all from the Hindu Marriage Act? In this channel, this news broadcaster goes on to say that the US have equal laws for all its citizens, even with respect to the personal laws.
American law treats all citizens as equal, and all of them must follow the same law. Well, that's not the case in India.
I'm very shocked that a news channel that is broadcasted throughout the world does not even know the simple fact that the matrimonial laws are different in each of the states in the US. A simple Google search would have helped them to figure it out. This YouTuber at least Googled and found one Hindu case in India that involved polygamy in 1952.
बहुत इंपॉर्टेंट केस है जिसमें एक आदमी को बिगमी मतलब 2 बार शादियां करने के लिए पनिश किया जाता है इस लॉ के अंदर.
It was punished. That's it. The Hindu Marriage Act was passed in 1955. Centuries-long Hindu practice of polygamy was abolished in a single stroke of the pen. Then she follows the same old pattern. Get hold of the punching bag, the Shah Bano case, and put all the blame on the Muslims.
तो इस पॉइंट पे सबसे इम्पोर्टेंट सबसे लैंडमार्क केस है शाह बानो केस. इस केस में शाह बानो को 40 साल की शादी और 5 बच्चों के बाद
No law journals or legal books studied. At least a reference to a few articles by legal experts would have made their arguments a bit credible. This video is about the continuing practice of polygamy in Hindu marriages under the complete benevolence of the Supreme Court and the worst discrimination faced by the Hindu women as a result. A short story before I move forward. When Flavia Agnes, the famous women's rights lawyer, had a conversation with a BJP minister, he said, we here refers to the Hindus, quote, we had abolished sati, female infanticide, polygamy, child marriage and dowry and liberated our women. Now we need to do the same for the other women in India using the Uniform Civil Code. As a reply, Flavia Agnes said, quote, my concern was less for the minority women and more for Hindus who are under the erroneous belief that they are governed by a modern, uniform, secular and a gender equal law. Let's jump into the 5 cases that proves the practice of polygamy in Hindu marriages. Please remember that the 5 cases that I have chosen to talk about are from hundreds of cases that were studied and analyzed for this video. Each of these cases are like thrilling detective stories, but in a tragic way. You will see a pattern emerging from each of these cases as determined by the famous women's rights lawyer Flavia Agnes. I have quoted all my references in the description box. Case 1. The Bhavrao Lokhande case, 1965. This is a landmark case decided by the Supreme Court a decade after passing the Hindu Marriage Act 1955. The complainant was the first wife. She complained that her husband Bhavrao had married the second time and abandoned her. Let's see what happened here. The first wife proved that her husband had married a second time by a Gandharva form of marriage popularly known as the Pat marriage. The ceremony involves the bride and groom sitting on a Pat, meaning a raised wooden stool. There were some chanting of hymns. The couple exchanged garlands and they struck each other's foreheads. This completes the ceremony. And who officiates this marriage? In the past, it was officiated by 3 people, a Brahmin priest, a Thakur and a barber. But with time, growing demand for the Brahmin priest, the Gandharva marriages were only officiated by a barber. So the first wife proved all the ceremonies in the court. So what happened? The trial court convicted the husband and the second wife. It was appealed by the husband in the sessions court. Again in the sessions court, the husband and the second wife were convicted, then there was an appeal in the High Court. The High Court again upheld the conviction against bigamy. But the turning point is when the case arrives at the Supreme Court. The Supreme Court acquitted the husband and held that the second marriage did not contain two important rituals, which is Vivaha Homa and Saptapadi. The Vivaha Homa is a sacred fire ceremony, while the Saptapadi is the 7 steps taken by the bride and the groom around the fire. So these are Brahmanic rituals. In addition, the court added that the bare fact of a man and woman living as husband and wife is not enough, and further it said that the society accepting them as husband and wife is not enough. And as a result, the husband was acquitted and was unofficially allowed to live in the unauthorized bigamous relationship. Wow, what a shocking judgment. Case 2, the Priya Bala Ghosh case, 1971. Complainant is again the first wife. The husband had admitted that due to the wife's conduct, he was compelled to remarry. This was used as evidence against him by the first wife. Let's see what happened here. The priest who performed the second marriage did not elaborate on the ceremonies, but merely stated that the marriage had been solemnized according to Hindu rites. The wife pleaded that the performance of the essential ceremonies must be presumed because of the presence of the priest. The trial court convicted the husband and the second wife and sentenced them to 1 year rigorous imprisonment and a fine of Rs 500. The Sessions Court upheld the conviction. The Calcutta High Court set aside the conviction and the case was escalated to the Supreme Court. The Supreme Court set the husband free, coming up with shocking observations. The first observation is that there is no dispute about the second marriage having been performed when the first marriage is subsisting. But relying on the previous judgment in the Kanwalram case in 1966, it said that the admission of the husband to the second marriage is not a sufficient evidence. The second marriage is invalid. This is quite shocking. That is, the admission of the husband is not a sufficient evidence. The second marriage is invalid because the essential Brahmanical religious rituals of Saptapadi and Vivaha Homa were not proved. The court further said that the sole responsibility of proving the second marriage is on the complainant, that is the first wife. Case 3, Baby Kar Roy vs. Ramrati Devi case, 1975. The Supreme Court grows more and more ignorant as the years pass on. Let's see what happened. The complainant is the first wife and she relied on the Special Marriage Act marriage certificate issued by the registrar proving the second marriage between her husband Misery Lal and the second wife. So what has happened was, after performing a bigamous marriage under the Hindu rites, the husband in fact registered the marriage under Section 16 of the Special Marriage Act. A certificate was issued by the registrar. Just for the sake of clarification, once a marriage is registered under the Special Marriages Act, the parties are bound by the provisions of the secular law regarding marriage and divorce, and the provisions of the Hindu Marriage Act do not apply to them. Registration under the Act is a sufficient proof of the validity of marriage. The trial court relied upon the certificate and framed the charges. When the second wife appealed against this in the Calcutta High Court, the High Court quashed the charges of the trial court on the ground that the certificate under the Special Marriage Act cannot be a proof of the marriage. What a disaster. They further said that it only records a declaration by the parties that they have gone through another form of marriage before the registration. Such declaration cannot be a proof of performance of the Brahmanical rituals of Saptapadi and Homa. Citing this, they acquitted the husband, discharging him of all the charges against bigamy. Before we move to the fourth case, a very interesting piece of report was released by the Committee on the Status of Women in 1974. As per this report, the rate of polygamous marriages among Hindus, Muslims and tribals were as follows. The rate of polygamy among Hindus was 5.06%, which was equivalent to 1 crore of the population according to the 1971 census. The rate among the Muslims was 4.31%, which was around 12 lakhs, and among tribals it was 17.98%. So by a stroke of a pen, that is by prohibiting polygamy in the Hindu Marriage Act 1955, no spectacular changes was brought about. Very surprisingly, the Supreme Court itself made a confession in 2005. In the Ramesh Chandra Daga case, the Supreme Court accepted that, quote, Despite codification and introduction of monogamy, the ground reality had not changed much, and that Hindu marriages, like Muslim marriages, continued to be bigamous. Unquote. Let me return to the cases. This is Case 4, Shakuntala versus Neelakant, 1973. The complainant is again the first wife. Let's see what happened. The first wife pleaded that the community had embraced Buddhism under the leadership of Ambedkar, and she had married as per the Buddhist rites of the community. She stated that she had embraced Buddhism after marriage, but she did not have any document as proof that her husband had also converted to Buddhism. So, how did the ceremony of marriage take place? In a mandap, the bride and the groom sat facing each other on two sides of the table and recited an oath in the name of Buddha and exchanged garlands and clothes. It was a simple ceremony where two consenting parties took an oath to be husband and wife. This was followed by a feast. There was no invocation by the sacred fire or saptapadi. Friends, if you're not aware, under the Hindu Marriage Act, the term Hindu includes Buddhists, and so the Buddhist rites should be recognized as valid. And since thousands of marriages were being performed in the Buddhist rites, the courts should lean in favor of recognizing these marriages as valid to avoid any large-scale social harm. But the Bombay High Court concluded that the first marriage as invalid and acquitted the husband. The judgment is a very notorious but very interesting one. Judges said, quote, "The concept of marriage under the Hindu law has not undergone any radical change by the enactment of the Hindu Marriage Act." The observation here by the judges in fact tried to belittle the Hindu Marriage Act. Remember, the purpose of the Hindu Marriage Act was to transform an ancient or a Vedic sanskar or a sacrament to a modern contract. The judgment continued, to a Hindu, marriage is not a matter of agreement or contract but a spiritual union of two souls. So holy invocation before the fire and saptapadi are its minimum requirements. This directly goes against Section 7 of the Hindu Marriage Act, which says that all customary and shastric rituals are acknowledged as valid for solemnizing a marriage. Looking at a marriage as sacramental union of souls between a man and a woman is an upper caste Brahmanical tradition. The artificial imposition of monogamy has not been able to regulate the customary practices of polygamy in India. Now over to the most interesting case. Case 5, the Chandra Manikyamma case, 1989. It is a case involving the comedy of errors by the High Court. It is a Kamma marriage, which is an Andhra Pradesh tradition. Complainant is the first wife. She complained that the husband had married a second time under Muslim tradition. Let's see what happened here. The first marriage was solemnized according to Hindu rites at the famous Tirupati temple. Subsequently, the husband remarried almost after 2 decades. Here is a curious turn of event. For the second marriage, the husband married in both Hindu and Muslim rituals. Now let's see the second marriage using Hindu rituals. Evidence of persons who had attended the second Hindu marriage was relied upon, who stated that there was a tying of the Mangal Sutra. Then he married the second wife according to the Muslim rites too. There are huge twists in each stage of the judgment. Please observe them carefully. The trial court convicted the husband and the second wife and framed charges against them. The Sessions Court acquitted them both, saying that the first marriage with the first wife was not proved by performing the essential Brahmanical rituals, and the second marriage, which took place with the second wife under Muslim rites, was in fact the first valid marriage, and hence it does not constitute bigamy. The High Court again acquitted the husband, but this time on totally different grounds. It said that the first marriage with the first wife is valid, which was exactly opposite to what the Sessions Court decided. The High Court went on to say that the second marriage under the Muslim law is invalid. The High Court decided it, stating the following important points. It said that the husband's admission to the first marriage is enough of a proof to validate it. Society accepting them as husband and wife were sufficient evidences. These 2 points were exactly contradictory to what the Supreme Court observed in the Kanwal Ram case, that the husband's admission of the truth of getting married do not count as evidence. The third point is even more surprising. It said that not all ceremonies performed 20 or 30 years earlier need to be proved. This is totally in contradiction to all its judgments, where it wanted the husband and wife to prove the Brahmanical rituals of Vivaha Homa and Saptapadi. And it further said that the second Muslim marriage was invalid as there was no marriage proposal ceremony and the proposal acceptance ceremony shown as evidence. In all the 5 cases, we see a pattern emerging. The lower courts and district magistrate who is familiar with the customs and traditions of the local area, they convict the husband for bigamy. Their convictions are overruled repeatedly by the High and the Supreme Courts, which is occupied by 76 to 85% of the upper caste judges. These judges upheld the Brahmanical rituals of Vivaha Homa and Saptapadi without any consideration to the diverse cultural landscape and customary rights of the local communities. They invalidated either the first or the second marriages, thereby saving the husband from the punishment due to bigamy. Further, where is the uniformity in judgments? In one case, they do not accept the admission by the husbands of their second marriages or sexual relationships. In other case, they accept it. In one case, they demand proof of Saptapadi and Vivaha Homa. In another case, they say it is not necessary. The Hindu Marriage Act clearly includes Buddhists among the Hindu fold, but the judges refuse to accept their marriage practices. As a blatant joke, in one of the cases, they call the registration of the marriage under the Special Marriage Act as invalid. What a disaster. But I can say that there is uniformity in one thing. Unofficial polygamy is upheld every time by the higher courts, and the Hindu polygamous husbands go scot-free. The husband escapes from conviction for their second marriages despite proof of cohabitation, birth of the child, or the community accepting the man and women as husband and wife. Since the Hindu law recognizes only monogamous marriages, the women in polygamous marriages are denied their rights. The Law Commission of India, in its 2018 consultation paper, said that gender discrimination is the cause of all the problems in the civil code bills or personal laws, and not the lack of uniformity. Under present circumstances, the Law Commission said that it was not in favor of the Uniform Civil Code. So where lies the solution? Can a uniform civil code not be implemented for now? It can be done only by making a secular registration of marriages via the Special Marriages Act obligatory for all weddings irrespective of the religion to which the couples belong. This was in fact advocated by the Hindu law expert Ronald Eugene Smith in his book India as a Secular State. This will allow no room for interpretation for Brahmanic or any customary rituals by the Supreme Court or higher court judges. However, a law in India remains only a paper tiger. Legislation should be followed by the organization of huge dedicated government awareness campaigns like the one for the polio vaccination programs to educate women throughout India that registration is the only way to marry a person. And more importantly, spread awareness that applying sindoor on forehead or exchanging garlands or tying the Mangal Sutra or taking oath before a deity in a temple do not constitute a marriage. This prevents her from falling into the trap of Hindu men who attract them into unofficial marriage-like relationships. In a largely conservative Hindu society, how many do you think will accept this kind of a uniformity?